Hi, this is attorney Mike Gravlin coming to you from Chicago as usual, and today we're going to take a look at Sovereign Citizen Court fail number 5. Let's do it.
Okay, that'd be great. All right, sir, you have an opportunity to consult.
Yes, ma'am. Just for the record, I'm a Moorish American Aboriginal Indigenous man.
And I am a unicorn. Let's do this thing.
Hold on, I'm going to write this down.
Moorish American Aboriginal Indigenous man.
You're talking too fast. Moorish American
Aboriginal Indigenous sovereign man.
I did a prior video called Sovereign Citizens in Court number 2, and Judge Hurley did the same thing with David Hall there. David Hall was talking about being the settler, the agent, and something else. I don't know, but he pulled the same routine. He said, all right, let me write all this crazy down so I just know what we're dealing with.
Okay, and as far as jurisdiction, man, according to case law, federal Supreme Court statutes, there's no discretion to ignore lack of jurisdiction.
Sir, I'm going to interrupt you because I'm going to repeat once again. We haven't even gotten to the issue of jurisdiction yet. The issue is whether you are going to appear in this courtroom with an attorney or without an attorney. Simply that small issue.
I understand
After we decide that issue, we will then move on to the issue of whether this court has jurisdiction over you, whether the charges are against you, all of those things. But
I understand,
today,
man. I just must say, man, to add on to what you're saying, jurisdiction, for the record, can be challenged at any time.
Well, this guy's a one-trick pony. He's got one argument on jurisdiction. He is not going to let it go. The judge tells him explicitly, hey, we're not doing jurisdiction. You don't have a pending motion on it. And he says, well, wait a second. I've got a jurisdiction argument. Hi, this is Frankie with the Sovereign Citizen Patrol, and I'd like to remind you to please hit like and subscribe, or I'll be personally offended.
See, Lantana versus Hopper. I'm raising jurisdiction now, man, asserting my constitutional right, and jurisdiction hasn't been proven. I haven't even had a rebuttal from the prosecutor, man. There hasn't even been a rebuttal.
Well, I've done 2 or 3 prior videos on this case, and in the last one I was pretty hard on this judge for being too lenient, and I still think she is. But I still think she's a smart judge and a good judge, and she's handling this. But she does get a little tougher here. It's just that it's frustrating to watch this because you don't have a pending motion, so we're not going to discuss jurisdiction. If you keep saying it, then we're going to go in contempt here. That's it. There's nothing else to do. This notion that the prosecutor hasn't sent a rebuttal, he doesn't need to. Jurisdiction's presumed. He's got no basis. Even if he brought a proper motion, he would lose. But this evidence of that the prosecutor hasn't rebutted it, he doesn't need to. That's why.
The judge is not supposed to be an arbitrator. I haven't had a rebuttal once from the prosecutor.
I can assure you I am not an arbitrator.
I understand. I've sent plenty of documentation asking for the returning of the documentation that the prosecutor office holds in regards to the fact of my identity and it proving that the state has no jurisdiction. And jurisdiction, again, can be challenged at any time. See Lantana versus Hopper. The burden shifts to the courts to prove jurisdiction. See 100 SCT 2502. There is no discretion to ignore lack of jurisdiction. See Rosemont versus Lambert 46-9 S2D 416. So, with that being said, man, can jurisdiction be proven for the record? I'm here on threat, question, coercion. Because I'm here, I'm not here on my own free will, other than threat, question, coercion. On the bill of recognizance sheets that was signed, Brandon Casimir isn't signed to that. That's who originally was charged. If you amend the court records to say and reflect that Brandon Casimir is also known as Cheyenne Cushmere Ill or Cheyenne Matola Cushmere Ill and any and all derivatives, that would be improper, and that would be illegal and unlawful because I'm not also known as Brandon Casimir.
Oh, Lord. He thinks that because he's just made up a new name for himself that he doesn't have to answer for his criminal activity.
The documentation that was given to the officer was given when he asked. I gave him authentic documentation from the state of New Jersey. That was authenticated, authenticated by the state of New Jersey. That officer had no jurisdiction. He asked where I was traveling. I said Timbuktu. This land is indigenously called Timbuktu.
You can't make this up. You can't make this up. He just decides to not only rename himself, but rename the state of New Jersey Timbuktu. I mean, it's fabulous.
I have the right to assert that right according to Article 6 of the treaty.
I'm going to interrupt you. There are some people that believe that this is the state of New Jersey. You may not believe that.
Okay, I kind of like the way the judge did this to him. There are people who believe this is the state of New Jersey. And the subtext, of course, is namely everyone except you.
But there are people that believe that this is the state of New Jersey.
Belief is not reason and facts, man. So because the state of New Jersey gives out authentication documentation on West State Street in Trenton, New Jersey, that's where I know the state of New Jersey to exist at. The state of New Jersey is not the soil of the land. So if anyone thinks that the state of New Jersey is the soil of the land, they're sadly mistaken.
What in the hell is he talking about? The state of New Jersey is not the soil of the land. What does that even mean?
Well, I think that there are probably some people that believe that you are sadly mistaken. But that is not the issue today. If you wish to address the issues I have brought before the... No. My issue today is, are you going to appear with a lawyer or are you going to appear without a lawyer? That is the only issue
I can't make an appearance.
I am not addressing the issue of jurisdiction.
Excuse me, ma'am. According to the federal case law in the United States Constitution and the United States Supreme Court,
and when the issue is raised properly before this court, I will...
It's being raised at any time, ma'am.
Excuse me a moment, please. There's a lot of talking going on in the courtroom that I can hear. If I can hear it, it is being recorded on our recording system. Two things. I don't think you want people on the recording system to know what you're saying. The second is you're interfering with me. If it continues, I will have to ask you to leave the court.
Objection, ma'am. According to Canon 3, a judge should accord to every person who is legally interested in a proceeding or that person's lawyer full right to be heard according to law. Asking us to leave the room, man, is
I'm not asking you to leave the room at all. I'm asking people who are speaking so loudly that they are interfering with the proceedings.
You asked me, am I going to proceed with attorneys? This is my society. And my British society exists beyond these walls. They have power of attorney, a written agreement, contractually. That's a constitutional right for us to be able to enter into...
What do you want them to do? Who is it actually that holds the power of
my entire counsel. This is my counsel.
And what do you want them to do?
Counsel, according to the constitutional law.
No. Tell me the actions that you want them to take in this courtroom today.
Counsel, I want my society members...
Sitting next to you?
Yes, counseling me.
That is not going to happen, sir.
Well, that is improper and illegal, man.
It is not.
Well, she is gently moving towards a little more discipline with them. Still not as fast as I like, but I do kind of like the judge in a way. I just wish she would maintain a little bit more order. But, obviously what he's asking is ridiculous. He's asking for people who are not party to the case and not attorneys to be sitting at counsel table, and that's just not allowed in any court in the United States.
And when you need to consult with them, you simply tell me. You can step outside. We have a private conference room on the left-hand side. You can consult with them there. They're not going to sit at the counsel table with you.
According to the Code of Judicial Conduct, man, that's not stipulated in Article 3.
There are a lot of things that aren't stipulated in Article 3, including the fact that you and I need to consult with one another. We need to be polite to one another. That's not there.
Absolutely.
So there are a lot of things that aren't.
I'm being polite as possible, ma'am.
I'm not suggesting otherwise.
Okay.
I am.
And just to add for the record, once more,
is this all on the record?
Yes, this is all
okay,
for the
then
record.
you let me know when you're finished putting it on the record, and then you and I will continue with our discussion.
Ma'am, jurisdiction can be challenged at any time. See Lantana versus Hopper. I'm raising the jurisdictional issues right now, man. You're asking me to assert whether or not I will, as an attorney at law, be representing me. That is impossible, unlawful, and illegal, and that is against your constitutional oath if you force me to get an attorney at law. I've already asserted the fact that jurisdiction can be challenged at any time. Of course, must prove on record all jurisdiction facts related to the jurisdiction asserted. We can't proceed until jurisdiction is proven.
You finished?
Yes, ma'am.
Okay. The issue we are going to discuss today, and I'm going to repeat this for the
I
last
move the
time.
court, ma'am, to dismiss this case for lack of jurisdiction.
Denied.
Yes, we've heard. You want to dismiss the case for lack of jurisdiction. There's a method to do it. You haven't done it. You don't have the underlying merits to do it. It's not going to happen, but, we've heard it 14 times now.
You
Jurisdiction
want
can
the
be
court?
challenged at any time.
Don't repeat yourself 4 times, please. I listen carefully, I write things down. If you wish to file that sort of an application with the court, it can be filed in writing
has already been filed, ma'am.
upon notice to everyone involved. I am not going to repeat myself again. I cannot conduct this proceeding with noise from the front row. If you lady, ma'am, and you gentlemen want to stay here, be quiet.
I'm not a gentleman, man. I'm a nobleman.
I'm not a gentleman, ma'am. Brilliant argument.
If you are a Moorish American, Aboriginal, Indigenous, sovereign man, whatever you are, be quiet in my courtroom. I cannot do this with people talking in the audience.
Can jurisdiction be proved, ma'am?
Sir, we are not dealing with the issue. I've told you before. You want to raise that issue, you file an appropriate motion.
It has been filed, ma'am.
No, I haven't seen it yet. I'll deal with it when I see it. It's not in the appropriate form. It's not going to get dealt with. The issue today is whether you are able to proceed in this proceeding with a lawyer or without a lawyer.
I don't think the cert proceeds, ma'am, and appropriate dishonest to jurors with the right of my society and law firm to consult me.
Well, all of that is well and good. The decision I'm going to make today is whether you are going to have an attorney at law who is admitted to practice law in the state of New Jersey or represent you. And that's what we're going to talk about now.
Excuse me, madam, the practice of law cannot be licensed by any state, Board versus Swift. A plenary license is not a license.
And what's the case that you just cited? What's the case you just cited?
Board versus Swear, man. Or Swear versus Board.
Did you read that case?
Yes, ma'am.
And what is it about? Why don't you tell me what the case is about?
Oh, I like this. She actually bothered to read a case because it's annoying. So he keeps making these same arguments, and of course she pulls one out and reads, and it doesn't stand for the proposition he suggests it does. None of them do. That's the usual thing. I get it in the comments all the time. People want me to chase down their 27 cites to nonsense. I'm like, no, just win before I look at it.
I'm not here to get in the subject matter, man. I'm simply stating for the record.
Sir, you cannot sit at that table and read part of the sentence out of a United States Supreme Court case and tell me that it means that the practice of law cannot be restricted in any way.
Uh-oh, the judge is finally losing patience with this, and I absolutely love it.
Now, it can be restricted for those who are U.S. citizens. I'm not a U.S. citizen. I'm a Moorish American, indigenous, sovereign. I've already stated this for the record.
Well, in fact, all that case had to do with whether the state of Georgia could stop someone who was...
Well, there you have it. We still haven't gotten anything done yet, including figuring out whether or not he's going to be represented, but I can see the judge is losing patience with this and is starting to move things along a little bit here. And I'm gonna try to go through the rest of these clips and all the way to the end of the case if I can. Here at Law Talk, we do a lot of videos answering common legal questions. We also do reviews of law in the movies and then on TV. We also share some of our more interesting cases. We're always putting out new videos. So if you like that, please hit like, subscribe, and ring the bell.